The funeral is over. The flowers have wilted. The casseroles have stopped showing up at the door. And 3 weeks after you bury your mother or dad, a letter arrives in the mail. It's from the state. And it's asking for money. A lot of money. Tens of thousands of dollars. Maybe more. The letter says the state has a claim against your mother's house. The same house you grew up in. The same kitchen where she taught you to make her pancakes. The same house she spent 30 years paying off dollar by dollar so that one day it would be yours. And now a government agency is telling you that before you can inherit a single brick of it, that debt has to be paid. Sell the house or find the cash. Those are the options. Here is the part that takes your breath away. This is completely legal. It is not a scam. It is not a mistake. It is a federal program operating in all 50 states, and it is doing exactly what it was designed to do. It is called Medicaid estate recovery. And most families have never heard of it until the day that letter shows up. So stay right here, because in the next few minutes, you are going to learn exactly what this rule is, who it actually applies to, the precise conditions that decide whether your home is at risk, the one panic move that families make that costs them the house, and the legal tools that families use to protect the home long before that letter ever gets written. Nothing here is complicated, but almost all of it is invisible until it's too late. Let's start with what this rule actually is, because the name itself is misleading. When most people hear the word Medicaid, they think of health insurance for people with very little money. And that's part of it. But Medicaid is also the single largest payer of long-term care in the United States. When someone needs a nursing home or assisted living or in-home care, and they cannot afford the $8,000, $10,000, $12,000 a month that care costs, Medicaid is what steps in to pay the bill. But here is what nobody explains at the time. That help is not a gift in the eyes of the law. It is more like a loan. And back in 1993, a federal law made it mandatory for every state to try to get that money back after the person who received the care passes away. The program that does this is Medicaid estate recovery. Every state is required to run one. Some run it gently, some run it aggressively, but they all run it. So who does it apply to? It applies to people who were 55 or older when they received Medicaid for long-term care. After that person dies, the state is required to look at what they left behind and to try to recover the cost of the care that was paid on their behalf. And for the vast majority of families, the largest thing the person left behind, the thing the state's eye goes to first, is the house. Now, here is the misunderstanding that costs families everything. And if you take nothing else from this video, take this. When a person applies for Medicaid to pay for their care, they are usually allowed to keep their home. The home does not count against them. The official word for this is exempt. The house is exempt. And the family hears that word and they relax and they think, good, the house is safe. But listen closely, because this is the trap. Exempt is not the same as protected. The home being exempt simply means it doesn't stop your mother from qualifying for help while she is alive. It says absolutely nothing about what happens to that home after she dies. While she's living, the house is exempt. The moment she passes away, that very same house becomes the first place the state looks to get its money back. Exempt while living. Exposed after death. Those are two completely different things. And the gap between them is where the family home disappears. That gap is just one of the quiet threats sitting under most families' feet right now. And there are several others that operate exactly the same way, hidden until the worst possible moment. The full walkthrough of these threats, along with the exact list of documents and questions to bring to an elder law attorney so you're prepared instead of panicking, is laid out in the Inheritance Quick Shield. And the link is in the description and the pinned comment below. But stay with this, because what comes next is the single most common mistake families make, and it is the one that turns a bad situation into a disaster. Here's the mistake. A family finds out late that the house might be at risk. And in a panic, they do the thing that feels obvious. They have mom sign the house over to the kids. Just give it away now, the thinking goes, and then there's nothing left for the state to come after. It sounds smart. It is one of the most expensive things a family can possibly do. And here's why. Medicaid has something called a 5-year look back. When a person applies for long-term care Medicaid, the state looks back at the previous 60 months, 5 full years, and examines everything that was given away or sold for less than it was worth. If your mother signed her house over to you 2 years before she needed care, the state sees that, and it does not say, well done. It imposes a penalty period, a stretch of time, sometimes many months, during which Medicaid will not pay for her care at all. The family ends up paying out of pocket for the very care they were trying to protect. The house is gone, given away, and the bills are now landing on the children anyway. And it gets worse because there's a second cost that nobody mentions. When your mother gives you the house while she's alive, you inherit her original purchase price for tax purposes. If she bought that house for $40,000 in 1985 and you sell it later for $400,000, you could owe capital gains tax on the entire difference. But if you had inherited that same house the proper way after her death, the law resets the value to what it's worth on the day she passes, and that capital gains tax can vanish almost entirely. So the panic move doesn't just trigger the Medicaid penalty, it can also hand the IRS a tax bill that never had to exist. This is why the giving it away instinct is so dangerous. It feels like protection. It is often the opposite. So now you know the threat and you know the trap. Let's talk about the part that should actually bring you some relief, because the picture is not as hopeless as that letter in the mail makes it feel. There are real conditions and real protections built right into the law, and most families have no idea they exist. First, estate recovery does not happen while certain people are still in the picture. If there is a surviving spouse, the state generally cannot force recovery while that spouse is alive. If there is a child under the age of 21, recovery is generally deferred. And if there is a child who is blind or permanently disabled, recovery is generally deferred for them as well. These protections exist in the federal law on purpose so that recovery doesn't put a widow or a vulnerable child out on the street. Second, there are specific exceptions that can protect the home itself. There's an exception for an adult child who moved in and provided care for the parent for at least 2 years, care that kept that parent out of a nursing home. There's an exception for a sibling who has an ownership interest and lived in the home. And every state is required to have a hardship waiver process for cases where recovery would create a genuine, serious hardship for the people left behind. And third, this is critical, estate recovery only applies if the person actually received Medicaid for long-term care in the first place. If your father never went on Medicaid, never needed it, paid his own way, or had other coverage, then estate recovery simply does not touch his home. This is not a rule that lets the government take any senior's house. It is a rule that applies under specific conditions to specific people after specific care was paid. Knowing exactly where you and your family stand on those conditions is the difference between fear and a plan. And building that plan, knowing which documents you already have, which ones you're missing, and the precise questions that tell you whether your home is exposed is exactly what the document checklist inside the Inheritance Quick Shield is built for. It's a single page. You fill it out at your kitchen table before you ever spend $1 on a lawyer, so that when you do sit down with an attorney, you're not paying $300 an hour for them to sort your paperwork. If you want to put real protection in place for your family, that checklist is where to start. And the link is in the description below. Now let's talk about the tools that families actually use to protect the home the right way well before any of this becomes an emergency. And a fair warning here. This is exactly the territory where doing it yourself is dangerous and where the right attorney is worth every penny. The goal of the next few minutes is not to turn you into your own lawyer. It is to make sure you walk into that lawyer's office knowing more than most people ever will, so you ask the right questions and you don't get sold the wrong thing. The first tool, and the one most people have heard of without understanding, is the Irrevocable Trust, sometimes called a Medicaid Asset Protection Trust. Here's the plain English version of how it works. You move the home into a special trust. Because the trust now owns the home rather than you owning it directly, after the proper amount of time has passed, that home is generally no longer counted as yours. And it is generally shielded from estate recovery. You can keep the right to live in the home for the rest of your life. You can keep certain benefits. What you give up, and this is the catch you have to understand going in, is direct control. The trust is irrevocable, which means you cannot simply change your mind next year and pull the house back out. That permanence is the price of the protection, and it is not the right choice for every family. It is a serious decision, and it absolutely needs an elder law attorney to set up correctly, because a single drafting error can undo the entire thing. And here's the piece that connects back to everything you just learned. Because of that 5-year look back, this kind of trust has to be set up well before care is needed. If you wait until your mother is already in the nursing home, the window has closed. The most powerful protection in this entire area is also the most time sensitive. The families who win this are the ones who acted while everyone was still healthy and nobody thought they needed to. The second thing to understand is what does not protect the home, so you don't waste your money. A simple will does not protect your home from estate recovery. In fact, a will sends the home straight into probate court, which in many states is exactly where the state goes to file its claim. A basic revocable living trust, the kind that's wonderful for avoiding probate, generally does not protect against Medicaid recovery either, because you still control the assets inside it. People hear the word trust and assume all trusts do the same job. They do not. The trust that avoids probate and the trust that shields from Medicaid are often two completely different documents, and confusing them is a costly mistake. Depending on your state, there are also tools like an enhanced life estate deed, which can, in some states, keep the home out of the probate estate. And there are long-term care insurance options that can pay for care so that Medicaid never enters the picture at all. Whether any of these fit your situation depends entirely on the state you live in and the specific shape of your family, which is precisely why this is a conversation to have with a qualified professional, not a form to download and guess at. So what should you actually do starting today? Here is the honest, practical path. Do not panic and do not give the house away. You now know why that backfires. The instinct to act fast is the instinct that costs families the most. Find out where your family actually stands. Is there a surviving spouse? Is there a disabled child? Has anyone in the family received, or is anyone likely to soon need Medicaid for long-term care? Those answers determine everything, and most of them you can figure out at your own kitchen table tonight. And if there's any real chance that long-term care is on the horizon in the next several years, this is the moment to talk to an elder law attorney, specifically one who handles Medicaid planning, not a general practice lawyer who does a little of everything. The best place to find one is the National Academy of Elder Law Attorneys. And the gold standard is an attorney who carries the certified elder law attorney credential, because fewer than 500 lawyers in the entire country hold it. Ask them directly, based on my state and my situation. Is my home exposed to estate recovery? And what are my real options to protect it? Bring your documents, know your questions. That single meeting can save your family the house. Because here is the truth that the letter in the mail never tells you. By the time the state is writing to your children, every good option is already gone. The protections in this area almost all depend on one thing, and it is the one thing you can never get back once it's spent: time. The 5-year clock only counts the days you started early. The family that learns about this rule today, while everyone is healthy and the sun is still out, is the family that keeps the home. The family that learns about it from a letter is the family that loses it. You are watching this today. That already puts you ahead of almost everyone. So take the next step while you still hold every card. Everything covered here, the threats, the traps, the exact checklist of what to gather and what to ask before you ever meet with an attorney, is laid out step by step in the Inheritance Quick Shield. The link is in the description and in the first pinned comment below. It is built to be read at your kitchen table in plain language, designed so that you walk into that attorney's office prepared, protected, and never blindsided. If this opened your eyes to something you didn't know, do one thing for the people you love. Send it to them. Send it to your spouse, your brother, your sister, your kids. Because the single most valuable thing you can give your family is not the house itself. It is the knowledge to keep it. And subscribe so the next threat to your family's legacy doesn't reach you in a letter. It reaches you here first, in time to do something about it. Your family worked a lifetime for what they're leaving behind. Make sure they get to keep it.